Tao Falilelo Jr. and Lex Logistics, case number 2020-00460.
Good afternoon, Your Honor. John Butler, P33908 on behalf of the plaintiff.
This is Alexandru Leahu for Lex Logistics.
Okay, all right. So today's date and time set for a hearing. The plaintiff is wishing to, or requesting of the court to grant a default judgment against Lex Logistics. Is that correct, Mr. Butler?
It is, Your Honor.
All right. Do you understand what's going on today, Mr. Leahu?
To be honest, not really.
This case begins with a business owner who thought he could handle legal matters without understanding a single thing, and that's exactly how a $25,000 disaster got started. The plaintiff's attorney calmly asked for a default judgment because the defendant failed to respond to legal documents that had real consequences. The judge asked the business owner if he knew what was going on, and he said not really, and that right there was the beginning of the end, ignorance. Maybe bliss, but in court ignorance is a wrecking ball. When you own a business and say you don't need to know the law, you're begging the system to come down on you hard. The defendant rambled about an employee who no longer works for him and said he didn't have to be garnished for nobody. He clearly had no idea what wage garnishment meant or why he was in court. This was the moment when the judge started losing patience, and so did everyone watching. It was obvious that he had ignored the certified mail because he assumed it wasn't serious, and now he was confused about why he was being held accountable for not responding to it. What he didn't understand was that courts don't forgive carelessness, they punish it, and when you pretend something isn't your problem, the law doesn't care, it becomes your problem instantly. This was a business owner who didn't read legal papers, didn't call a lawyer, and didn't respect the court's authority.
Mr. Tao used to work for me. He doesn't work no more. I don't know where he's at and all that. And I'm not really familiar with all this kind of laws, but I don't have to be garnished for nobody. I don't see how did I receive all kind of whatever stupid stuff what the person who used to work for me, I don't know, apply and all that. To be honest, I'm not familiar at all.
So, Mr. Leahu, the way this works is if you have an employee, okay, who has a court case against them, and they owe money, the person who is owed the money, they can get a part of their wages, and you would have to participate in that, and that's why Mr. Butler and his client is looking for that information to see if monies that Tao Falelo, monies that this person earned, that Mr. Butler's client has a right to a portion of it, that they're able to successfully get those monies. And so you're saying right now this person does not work for you?
No, it doesn't work for months and months. No.
When did he work for your company?
Last year.
Your Honor, I see that the wage garnishment was filed. Looks like October 4th, 21. We sent a failure to disclose letter in November, no response. We entered a default against the garnishee defendant last November, no response. And now we're seeking a judgment.
The judge explained step by step what garnishment is and why the plaintiff's attorney was right to seek a judgment, yet the defendant kept going in circles, repeating that the employee didn't work for him anymore and blaming the court for not calling him directly. He talked about how many letters he receives every week and that he simply ignored this one because it didn't have his name on it. He admitted he didn't even look into it until the last possible second, and by then it was too late. This kind of thinking is how small businesses crash and burn in slow motion. He said he didn't know what garnish meant until recently, and he wished someone would have called him instead of mailing legal documents. But that's not how the justice system works. If you can't handle your mail, how are you handling payroll taxes, or contracts, or employment liability? The judge remained calm, but you could hear the frustration build as the excuses piled higher and higher. This wasn't about confusion anymore. This was about neglect, pure and simple. and while the court was willing to give 30 days to sort things out, that was mercy, not entitlement. This defendant treated the legal system like junk mail, and that arrogance could cost him everything, because the court takes deadlines seriously even if you don't.
It seems like if he would have simply answered the garnishment when it was originally filed, we wouldn't be here today. And if he's not a lawyer, perhaps he should talk with one, but we've had to do a lot of extra steps that would have been helped by filing the garnishment when he was required to.
Well, when the request ultimately is for a $25,000 judgment against Lex Logistics, I think it would be probably appropriate for the court, especially if it sounds like Mr. Falelo didn't work there all that long, that Mr. Lehu have the chance to at least talk to a lawyer about this. Mr. Lehu, you have an obligation when it's not, court stuff is definitely not stupid stuff, because it could absolutely have a huge impact on you financially. But that being said, if you don't have to deal with this very often, it would be something that is new.
In 20 years, I had some companies in 20 years, first time when I ever saw something like this. To be honest, I saw that it's not on my name. I said, Lex, I never pay attention. Now, when I got it, the last one, I really look a little bit into it, and I start pretty much look into the meaning of garnish and all that. And then I start calling your court and all that. And I say, hey, what the heck this one has to do with me? And then they start explaining me that I have to show to the court. I have to explain to you that he doesn't work for me and all that. But for me, maybe if somebody called me, explain me more about it. But I didn't even pay attention to the sum, to nothing. Once I didn't see my name, I get 100 stuff in my mail for a company. To be honest, if it's nothing, I know I didn't do nothing wrong. I don't pay attention to this kind of stuff.
The judge told him in plain terms that these legal documents matter, and if you run a business, you are responsible for following the law even if you don't fully understand it. The defendant kept asking what could he possibly do now, and the answer was simple: talk to a lawyer immediately, because no one in court would hold his hand through the process. The attorney explained that the plaintiff had already tried multiple times to get a response, including a failure to disclose notice and a default filing. Still nothing. The defendant kept pushing back, saying this was all new to him and unfair, that he had to pay for someone else's debts. But what he didn't realize was that he wasn't being sued for the debt. He was being sued for ignoring the process. When the court says garnish wages and you refuse, then you're not just clueless, you're in contempt. His whole defense was built on not knowing and not caring, and now the hammer was coming down hard. At one point, the judge had to stop him from interrupting and reminded him that ignoring a court order is not just rude, it's expensive, and in this case, possibly fatal to his business. The defendant said he didn't even save the court documents, just took a screenshot and threw the rest away, and the courtroom fell into disbelief.
But you need to go talk to a lawyer, because these answers, like I didn't know, or, those aren't valid legal answers for your failure to answer this garnishment back last year. So I'm willing to discuss these things, but you need to talk to a lawyer about this, because right now, Mr. Butler is looking to get a $25,000 judgment against your company. $25,000 judgment against your company. I would think at that point in time, it might make sense to talk to a lawyer. I can't tell you what to do. I can't give you advice. In my position, if I give you advice, then it looks like I'm showing you favoritism over the other side. I can't do that. And so, Mr. Lehu, I'm sorry that you haven't had to deal with this in 20 years. Thank goodness you haven't. But you're having to deal with it now. So I'm going to adjourn this 30 days. You might not have to hire an attorney, but you can at least talk to an attorney. So use that time. I will tell you.
Okay, but what do I have to do if the only thing what I can tell you, he doesn't work for me and all that? Even if I talk to a lawyer, what can I do in this case? Because I don't have nothing to do to this person, and I don't have no idea what kind of loan or what kind of stuff he did.
The judge emphasized that even if the employee no longer works for him, there was a point in time when he did, and during that time the employer had a legal duty to comply with the court order, and the employer failed that duty repeatedly. He tried to say he was too busy to take an hour off work for court matters, but when $25,000 are on the line, your time becomes a very poor excuse. The plaintiff's attorney sat quietly as the defendant unraveled his own case word by word. The judge reminded him that he can't give legal advice and that his job is to stay neutral, but this was clearly a case of someone completely unprepared to run a company, let alone navigate a court system. The judge told him plainly, talk to a lawyer in the next 30 days or come back and face the consequences, and those consequences will not be small. The defendant insisted he didn't understand what to do or who to call, and that he had no paperwork left because he threw it away. The judge reminded him again that every legal notice he received had the lawyer's name and number on it, and he still chose to toss it out. This wasn't a misunderstanding, this was neglect, and now it was time to deal with the outcome.
Oh, I know, but Mr. Lehu, but he did work for you, and there was a time where they notified you, the other side, that's basically said, hey, if you're paying this guy some money, a portion of it has to come to us. And you didn't answer that. And that's a problem. And so that's right now, he's not working for you. That's fine. Then you don't owe them like any monies going forward. But there was a period of time where he was working for you. You need to talk to a lawyer about what your obligations are at this point when it comes to Zeal Credit Union.
Okay, and what we can do right now, because I cannot go back and forth. Even right now, I had to stop work for 1 hour just for this kind of person, which I don't have no work.
Sir, if you find, if you call the local bar association, if you look
okay,
for
but
a
what
business,
do I have
if you
to
look
do
for a
in this
business,
case? Okay, what do you want from me now? Okay, this guy doesn't work for me. What do you want from me?
Mr. Lehu, you need to stop interrupting the court. That's what needs to happen first and foremost. Stop interrupting me. All right. So I don't have to, frankly, right now you have no good answer for this. And the court could simply grant his motion for default. And then your company would have a $25,000 judgment against it. Why? Because you weren't willing to take a couple minutes, an hour. You say it's taken an hour versus 25,000. I can't understand that conceptually, sir, why you wouldn't.
This is only in this country can happen for me to own to somebody else some money, and I have to deal with this. You're telling me that it's my fault that I didn't pay attention to one letter. They didn't call me.
Sir,
how should I, if I never pay attention to the money and all that? I didn't do nothing.
Sir, if you're a business person, then you are held to the same standard as any other business person running a business in this state, in this country. And that is, if you get a request of this nature, you're to respond to it. And you didn't. And so I'm giving you a chance here to talk to a lawyer and see what your options are. Now, you say you don't know anything about this. There are so many lawyers who do. And you say, I don't even know what to do or what to say. If you hand these documents to a lawyer, they will know what to do. So I'm adjourning it 30 days. If you want to come back here and say, I don't know what's going on, I don't really understand, and I've given you 30 days to go find out, then I'm not going to have a lot of patience for you, Mr. Lehu. But I'm giving you 30 days to have a conversation that probably will take less than an hour.
Tell him to send me again the paperwork, because I don't have the paperwork no more. I just made a screenshot for this court date. Tell him to send me another copy of those. I'll look into it with the lawyer, and that's it.
I would say talk to the lawyer about that. He or she can call Mr. Butler for any documentations that are any paperwork that's outstanding. I'm sure you have Mr. Butler's phone number. If you contact, if you give your lawyer, Mr.
No,
Butler's
I don't have nothing. I just made the screenshot for my meeting ID, and that's it. I don't have nothing, to be honest.
We said, how did you know about today?
Because I made a picture from that letter to the meeting ID, and that's it.
The meeting ID has the notice has Mr. Butler's the other attorney's name and number on it.
But I called him at that time when I call your court to look into this, and I throw the paper away. I don't have it no more.
As the session closed, the judge extended a rare second chance, but made it clear that if the defendant returned without a lawyer or a plan, the court would issue the default judgment, and that would be the end. The man who claimed he loved America now faced the reality that American courts don't care how patriotic you are. If you ignore their orders, he threw away evidence, ignored deadlines, and dismissed the seriousness of the situation, then acted shocked that it came back to haunt him. He asked the court to rescind the documents, as if that would reset the clock. But that's not how any of this works. The judge told him to have his attorney contact the plaintiff's counsel directly and get whatever was missing, but warned him not to waste this opportunity, because if he did, the judgment would be swift and unforgiving. The defendant tried to explain again that he was confused, that by now the court had heard enough. This was no longer about confusion. This was about accountability. A man ignored certified letters, ignored court deadlines, ignored the law, and now the law was ready to crush his ignorance. The only question left was whether he would wake up in time or let his own business become a casualty of arrogance and neglect. So, if you want to see more chaos like this, hit that like button and subscribe, because we've got plenty more where this came from, and trust me, you won't want to miss the next one.